multiple counties that I practice in. The officer will even list his agency in a separate affidavit,
Again,
but still because
I'll
that...
object.
All right, to both
If
counsels.
he's going to object.
Yes, Your Honor, I'm here. One infraction matter, Susan Kovalenko, Kovalenko, and I just have a couple of preliminary motions to make. I don't think this will be a long hearing, Your Honor.
All right, go ahead.
This on the notice of infraction that was provided in discovery. There's a lack of agency identification in the officer's signature and sworn statement. The infraction is invalid under RCW 55010 and RCW 550050 as the signature on the notice of infraction lacks the required agency per RCW 550010E subsection 3 for law enforcement declarations, failing to provide it in the standard form as required in the statute, which undermines the authenticity. It also, by not having the agency identification, the notice and statement omitting the employing agency violate IRLJ 2.1 subsection B4 for clear officer identification to establish authority and validity. Without these details, the report fails to prove jurisdiction in Clark County or Battleground, rendering the affidavit defective under IRLJ 3.3C. So we're asking that the infraction be dismissed, suppressed for those reasons, and then be dismissed, Your Honor.
Can you give me that statute you were citing as well, one more time?
RCW 550050, and the other statute is RCW 550010, and then specifically subsection 3E. It will discuss how the officer's sworn signature needs to be in substantial compliance with the example form given. Oftentimes we see an officer put his agency in the actual signature block or include it and incorporate it through their separate affidavit or even on the notice of infraction. Here we have the officer state that he is in fact an officer in the state of Washington, but nowhere else on the infraction, anywhere does it list anything about where he works, what agency, what his jurisdiction and authority is over this case. So without those, it really renders the rest of the notice of infraction inadmissible, Your Honor. So we're asking for suppression.
And if Your Honor, if I may be heard briefly.
Absolutely.
My understanding, this issue has come up a number of times. I've discussed with law enforcement this issue. I have received, since the last time this issue came up, a Washington State Peace Officer certification. Each officer in the state of Washington is certified to write infractions by the Washington State Commission, not their agencies. So Battleground does not say, we give you authority to write infractions. Ridgeville does not say that. It is, and I'm going to read from a sample state certification I got, Washington State Peace Officer certification.
Your Honor, I'm just going to object to things being entered into the record, like a statement from which I have not been provided in discovery and had a chance
hold on. Hold on.
Yeah, give us a moment
let
here.
me finish.
I'll give you a chance to respond.
You know what? I won't read it into the record, but I'll tell you under RCW 43101.095 and 43101.157, these are the statutes that officers have to meet the requirements of to write tickets anywhere in the state of Washington. This infraction states that this person is commissioned by the state of Washington. They signed with their badge number, they signed with their name. They don't need to, this would be form over substance. If any court is going to say that they have to say, oh, and by the way, I'm employed by XYZ, it doesn't matter. As you can see from this infraction, this was a target zero emphasis. Target zero emphasis are MOUs between multiple agencies where they come to a specific city and write traffic tickets. So I think the argument fails and we can go forward with the contested hearing.
Response.
That's an excellent argument, Your Honor, but it fails to address the actual merits of my own argument and how the officer didn't comply with those RCWs. It may be frustrating and it may seem like it's form over substance, but the law does apply here, and the facts of the situation when applied to the law dictate that this infraction must be dismissed. The statute is clear. There must be substantial compliance with the officer providing his agency. IRLJ 2.1 and 3.3 are also clear. We don't have any foundational authority here. We don't have any agency details. We don't have jurisdiction. There's just a plethora of issues. And this is an issue that comes up in counties across the state. And there's different rulings on different situations, but in this situation, the officer doesn't even state it. We'll see substantial compliance because the officer will attach a separate affidavit where at the beginning he will list who he works for, or he will actually put it in his signature or indicate it somewhere. Sometimes there's even an agency number that goes at the top of a notice of infraction that most people don't even know about. But here we don't have any of those. It's not even close to substantial compliance. So that was a compelling argument we heard by Ms. Carmi, but we need to apply the law to the facts given, and I think it's pretty clear what must be done here today.
Counsel, can you give me that specific statute again that you're citing? Because the two that I see the 550-050 and the form, and I see that, and I see compliance there, but what I'm looking at is the other one you cited that it sounds like you're relying more on. What was the other one? The
550, 050, and 010 is what I am primarily relying on. The other statutes are IRLJ 2.1 and IRLJ 3.3C.
And Your Honor, I have
So
read those. And
give me 1 second, Ms. Carmi. In 550-010, what specifically are you alleging is the defect?
3E, the signature lacks the requirement agency for law enforcement declarations. It fails to substantially comply with the standard form that is provided in RCW 550-050.
But in 050, all I am seeing is that they have to do a penalty of perjury statement with their name. That is what's been done. There is a date, there's a month, there's a year, there's their name, there's even more, there's their badge number.
And that's when the 0103E comes into play, Your Honor, where it lists specific requirements by law enforcement officers to list their agency. And it must be in substantial compliance. The argument here isn't whether he did it or not. The argument and the issue is whether the officer substantially complied with the statute. And here we don't have any proof. We don't have any indication. In multiple counties that I practice in, the officer will even list his agency in a separate affidavit.
Again,
but still, because
I'll
that
object if,
All right, to
if
both
he's-
counsels.
If he's gonna object to me reading in a certification, I'm gonna object to him bringing in evidence from other counties.
I'll disregard the evidence that should not be considered. I'm going to rule on this preliminary motion based on the admissible arguments, not referenced extraneous hearsay statements. I do believe we're looking at substantial compliance, but I am inclined to looking at the plain language of 550-010 subsection 3D, or excuse me, 3E. It is express, it is unambiguous, and there's no other way that I can read that. It says to sign means to affix or logically associate their full name, department or agency, and badge or personnel number. Department or agency, while I do believe there is information that contains being a commissioned police officer in the state of Washington, I'm not finding that that's the listed department or agency that's intended by the statute. I'm not finding that there's enough compliance here that was met. So I am granting this preliminary motion. I am finding that it's deficient on its face because it doesn't include the department information or any agency information for this specific declarant in any of the signature boxes, both on the first page on the face as well as on the page 3. It is the same signature, but nothing indicating the agency or department as expressly required by the statute. Anything further from your perspective on this, counsel?
No, Your
Mr.
Honor.
Kemp?
No, Your Honor.
All right, anything further from your perspective?
No,
Ms.
Your
Carmi?
Honor.
All right, this is dismissed. Thank you.
Thank you, Your Honor.
All right. Mr. Carrasco, thank you for being present. We've got your client scheduled here, Mr. Juan Rangel.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.